President Trump was told by the Attorney General that he is in the Jeffrey Epstein files. He was told he was in the files 2 months ago, and then last week said, no, he wasn't. He was. This was during a briefing on the findings of the Justice Department's review of the documents related to Epstein. That's according to sources familiar with the discussion. Those sources said the Justice Department's review found that the files appeared to include several unsubstantiated claims that they determined not to be credible, including those relating to Trump. Bondi also raised in the meeting that several names of other high-profile figures were mentioned, the official said. And it's worth noting that being mentioned in the files does not in any way indicate wrongdoing. The Wall Street Journal, who first reported this story, said that AG Bondi, who was joined in the briefing by her deputy Todd Blanche, who previously served as President Trump's attorney in the criminal hush money trial. The briefing took place in May, weeks before the Justice Department released a memo on July 6th.
This just happened. A massive internal rupture has occurred within the Department of Justice, and it changes the entire trajectory of the current administration. We have received confirmation of a specific event that took place inside a federal courtroom filing and during a high-level briefing. This is not speculation. This is an admission of a mechanized cover-up operation involving government resources. The Attorney General of the United States, Pam Bondi, has formally admitted that hundreds of federal employees are currently working to manage the release of sensitive files related to the Jeffrey Epstein network. This admission comes after President Trump was explicitly told by his own Justice Department officials that his name appears in these documents. This creates an immediate constitutional crisis. We are looking at the direct weaponization of the Justice Department to shield the president from a law that he personally signed. This is a moment where the survival of independent institutions is being tested in real time. The stakes are total party collapse and a breakdown of the rule of law. Here is exactly what is happening right now.
Attempting to close the book on Jeffrey Epstein, which said, quote, no further disclosure would be appropriate or warranted. That memo kicked up a furor in the president's supporters, among them, that continues to this day. CNN reached out to the White House about the Journal report. Their response read in part, this is nothing more than a continuation of the fake news stories concocted by the Democrats in the liberal media. That was their response. But we now know the president was told he was in the files, which he was specifically asked about last week.
What did she tell you about the review? And specifically, did she tell you at all that your name appeared in the file?
No, she's given us just a very quick briefing.
No, he says. We asked the Justice Department for reaction to the reporting. Attorney General Pam Bondi and Deputy AG Todd Blanche, the two officials in that Trump briefing, according to the Wall Street Journal, they released a statement.
We need to walk through the facts of this situation step by step because the timeline tells the whole story. This begins with a specific briefing that took place inside the executive branch. President Trump was informed directly by Attorney General Pam Bondi that he is named in the Jeffrey Epstein files. This was not a rumor. This was a formal notification. The briefing happened 2 months ago. At that time, the president was told the information was there. Last week, he denied this. He said he was not in the files. That statement was false. He was told he was in the files during a specific review of the findings by the Justice Department. Sources familiar with that closed-door discussion have confirmed the details. The Justice Department review found that the files included various claims. Some of these claims were determined not to be credible by the department, including some relating to Trump. However, the files exist and the names are there. During this same meeting, Attorney General Bondi mentioned that other high-profile figures were also named. It is important to state that being named in these files does not automatically prove a specific crime was committed. However, the context of who was in the room matters. The briefing included Attorney General Bondi and her deputy Todd Blanche. Todd Blanche previously served as President Trump's defense attorney in his criminal hush money trial. This means the people managing the release of this information are the same people who have professionally defended the president in criminal court. This briefing took place in May. That was weeks before the Justice Department released a memo on July 6th regarding the files. To understand why this is a crisis, you have to look at the job description of the Attorney General. That person is responsible for enforcing the law and representing the people. Their job is not to protect the president or hide evidence. Their job is to uphold the rule of law. The conflict here comes from a specific piece of legislation. Congress passed the Epstein Files Transparency Act. This was not a partisan bill. It had overwhelming bipartisan support. The vote in the House was 427 to 1. The Senate passed it by unanimous consent. President Trump signed this bill into law on the 19th of November 2025. The law is very simple. It requires the Justice Department to release all files related to the Jeffrey Epstein investigation. It requires them to be searchable. It requires transparency so the American people can see who was connected to one of the most notorious illicit exploitation networks in history. The law gave the Justice Department a deadline of 30 days. That deadline passed on the 19th of December 2025. The Justice Department did not release the files. Instead, they released a small batch of documents that were mostly already public. They released press clippings and old court records. They heavily redacted the new information. When Congress demanded an explanation for why the law was being ignored, the Attorney General made a stunning admission. Pam Bondi admitted that the Justice Department currently has over 500 people working on reviewing these files. This is a critical number. You do not need 500 people to release documents that are required by law. You need a small team to redact personal information for victims. When you assign 500 people to a review team, you are building an army to manage information. It has become clear that the goal is not to release the files. The goal is to bury them. The goal is to protect specific individuals. One of those individuals is Donald Trump. The Attorney General has effectively admitted that the agency is conducting a cover-up. The Justice Department sent a response to the White House regarding reports about these files. They claimed the reports were fake news stories, but we know the president was told he was in the files. When asked specifically about the review last week, the president claimed he was given a very quick briefing and denied being told his name was there. That denial contradicts the reporting from inside the room. The law requires a searchable format. It requires a comprehensive release. The executive branch is currently burying these files to protect powerful people. Bondi missed the deadline. She released a joke of a first batch. It was a public relations stunt designed to look like compliance. When the courts and Congress started asking questions, the truth about the 500 reviewers came out. Reporting from multiple sources indicates that these reviewers are working overtime. Their specific task is to redact instances of Donald Trump's name. They are scrubbing the president's connections to the Epstein network from the public record. This is the definition of a cover-up. It is using the Justice Department as a personal protection service for the president. Representative Dan Goldman sent a letter to Attorney General Bondi. He expressed grave concern. He stated there appears to be a concerted effort to delay and prevent the release of the files. He warned that this might be happening at the direction of President Trump. Goldman noted that FBI agents were working to flag and redact documents mentioning Trump. He reminded the Attorney General that her duty is to the public, not to the president's reputation. This letter was a formal warning. Congress knows what is happening. The situation is even more serious because of the nature of the evidence. In a recorded encounter that was later made public, Bondi admitted there are tens of thousands of videos involving Epstein and minors. These are videos of severe exploitation. The FBI possesses these videos. They are going through every single one. There is a legitimate need to protect the privacy of victims in those videos. No one disputes that. However, Bondi is using that legitimate concern as a shield. She is claiming she needs to protect victims, but the resources are being used to protect political figures. When Bondi appeared before the Senate Judiciary Committee, she refused to answer questions about the president. She would not say how many times Trump's name appears in the files. She would not say who ordered the FBI agents to flag his name. She deflected and attacked the people asking the questions. That is obstruction. Now the courts are involved. A group called Democracy Docket is suing the administration. They are demanding that the courts enforce the Transparency Act. They are demanding that Bondi comply with the law. Democrats in Congress are looking at legal options. This includes holding the Attorney General in contempt. She is violating a federal statute. She is refusing to comply with a law the president signed. The objective is to keep the American people from seeing the evidence. The files contain information suggesting Trump knew about the illicit activities. They suggest he flew with Epstein more times than he admitted. They suggest he was part of the network. All of that information is sitting in the Justice Department right now. Bondi is using 500 reviewers and months of delays to ensure it stays hidden. This is not just about delayed paperwork. This is about the Attorney General actively covering up evidence. It is about using the Department of Justice as a private law firm. It is about violating federal law to keep political secrets. The admission of the 500 reviewers proves the scale of the operation. You do not mobilize 500 federal employees for a standard review. You mobilize them for a crisis management operation. The law required a searchable database. It required an unredacted list of government officials to be given to Congress. The point was to stop the government from burying embarrassing information. Every administration tries to hide things. This law was designed to stop that. Trump signed it, and now his administration is breaking it. The deadline came and went. The excuses began. Bondi claimed it was complicated. She claimed there were millions of pages. But the admission of the massive staff count destroys that excuse. If you are simply releasing files, you redact names of victims and release the rest. You do not need an army. The 500 people are scrubbing. They are using a fine-tooth comb to find anything damaging. They are identifying every reference and every connection. They are making sure those connections do not appear in the public release. When Representative Goldman asked Bondi if Trump ordered these redactions, she did not say no. She refused to answer. In a legal setting, a refusal to answer speaks volumes. If this were a normal bureaucratic process, she would have defended it. She would have explained the standard procedure. She did not do that because this is not a standard procedure. We know some of what is in the files from previous leaks and other cases. There are flight logs. There are emails. There is evidence of a relationship much closer than the president admits. The full Justice Department files contain much more. They likely contain more photos and more correspondence. Bondi is sitting on all of it. She has admitted the existence of tens of thousands of videos. She uses these videos to justify the delay. She claims they need time to review them for victim privacy. But if she has had months to review them and she has 500 people, she should have released more information by now. She has not. The pattern is clear. The privacy of victims is being used as a tool to hide the exposure of the president. The first release in February 2025 was garbage. It was material anyone could find on Google. Lawmakers from both parties called it inadequate. They said Bondi was violating the spirit and letter of the law. When pressed, she gave more excuses. She is stonewalling because compliance would be politically fatal. The courts are now threatening contempt. They are ordering expedited processing. Congress is issuing subpoenas. They are using oversight power to force transparency. They know this is a deliberate cover-up. Bondi's behavior in hearings confirms it. She is hostile and defensive. She attacks the questioners instead of answering the questions. That is the behavior of someone who has been caught. She is trying to run out the clock, but the strategy is failing. The cover-up is becoming a bigger story than the files themselves. It is now a story about the Attorney General breaking the law. It is about a constitutional crisis where the executive branch refuses to follow the laws passed by the legislative branch. It is about the president putting himself above the law. We need to analyze why this specific event represents a breaking point for the institutions of government. This is not just another political scandal. This is a structural failure of the checks and balances designed to keep the American government functioning. When we look at history, we often see attempts by presidents to hide information. We saw it during Watergate when Richard Nixon tried to use the CIA to stop the FBI from investigating the break-in. We saw it when Nixon fired the special prosecutor during the Saturday Night Massacre. The parallel here is striking because it involves the manipulation of the Justice Department to serve the personal legal needs of the president. The difference in this situation is the scale and the brazenness of the operation. In past scandals, the cover-ups were often conducted by small secretive groups within the White House, the plumbers, or a few loyal aides. In this case, we have the Attorney General of America openly admitting to utilizing a workforce of 500 federal employees to manage this suppression. That is not a covert operation. That is the institutionalization of a cover-up. It turns the Department of Justice from a law enforcement agency into a political defense firm. This matters because the Department of Justice is the only entity with the power to enforce federal law. If the head of that department decides that the president is exempt from the law or that the department's resources should be used to shield the president, the entire system of accountability breaks down. There is no one left to enforce the rules. The legislature can pass laws, as they did with the Transparency Act, but if the executive branch simply refuses to follow them and uses its vast resources to obstruct them, the law becomes meaningless. We must also look at the specific mechanism of fear and control being used here. The excuse of protecting victims is a powerful rhetorical shield. It makes it difficult for opponents to attack the delay without seeming insensitive to the victims of terrible crimes. This is a cynical tactic often seen in authoritarian regimes, where the government claims it must restrict information for the safety or privacy of the people, when in reality it is restricting information to protect the regime. By hiding behind the victims of the Epstein network, the administration is trying to make the cover-up morally unassailable. However, the sheer number of reviewers, 500 people, undercuts this defense. In the history of Freedom of Information Act releases or declassification reviews, teams are rarely that large. A standard review team might consist of a dozen lawyers and specialists. An army of 500 suggests a level of scrutiny that goes far beyond privacy redactions. It suggests a frantic effort to control a narrative that is too large to contain. It indicates that the volume of damaging information is massive, and the effort required to sanitize it is overwhelming the system. This also highlights a shift in the nature of the scandal. Originally, the Epstein scandal was about the past behavior of Donald Trump, who he met with, where he flew, and what he knew 20 years ago. That is a historical and political problem. But the actions of Pam Bondi and the Justice Department have transformed this into a present-day criminal issue. Obstruction of justice is a crime. Misuse of government funds is a crime. Violating a federal statute is a breaking of the oath of office. We are no longer talking about what happened at a villa in the early 2000s. We are talking about what is happening in the Department of Justice headquarters right now. This creates a dynamic where the cover-up becomes more dangerous than the crime. In political history, this is almost always the fatal error. The original act might be survivable, spun as a mistake or a lapse in judgment from a different era, but the cover-up involves active lying, active resource misuse, and active violation of the law while in office. It implicates everyone who touches it. Every one of those 500 reviewers is now a potential witness. Every memo sent by Bondi is potential evidence. By expanding the circle of the cover-up to include hundreds of employees, the administration has exponentially increased the risk of leaks and whistleblowers. We are seeing a clash between the unitary executive theory, the idea that the president controls all information in the executive branch, and the statutory power of Congress. Congress passed a law demanding these files. The president signed it. Now the president's appointees are defying it. This is a test of who actually runs the government. If Bondi succeeds in burying these files, it establishes a precedent that the president can ignore transparency laws whenever he chooses. If Congress and the courts succeed in forcing the release, it reestablishes the principle that no one is above the law. The fear within the administration is palpable. You do not deploy 500 people unless you are terrified of what is in those boxes. You do not stonewall the Senate unless the truth is politically fatal. The behavior of the Attorney General, the hostility, the evasion, is the behavior of an institution under siege. They know they are breaking the law, and they are gambling that they have enough power to get away with it. We need to look at what happens next, because the consequences of this standoff are going to unfold rapidly. In the short term, we are going to see a fierce escalation in the legal battles. The courts have already signaled impatience. We can expect federal judges to issue strict scheduling orders. They will likely demand that the Justice Department produce the files in batches on a very tight timeline. They may even appoint a special master, an independent third party, to review the redactions. This would be a nightmare for the administration because it would take the control out of Bondi's hands. Congress will also escalate. We are likely to see contempt proceedings against Attorney General Bondi. While contempt of Congress is often difficult to enforce, it carries significant political weight. It formally brands the Attorney General as a lawbreaker. We will also see more subpoenas issued to lower-level officials. Congress will try to bypass Bondi and get testimony from the people actually doing the reviewing. With 500 people involved, the likelihood of someone talking is extremely high. We should expect leaks. We should expect whistleblowers to come forward to the press or to congressional committees describing exactly what they were told to remove from the files. In the medium term, the political damage to the president will deepen. The narrative has shifted. It is no longer about fake news. It is about a confirmed government operation to hide the truth. This erodes trust even among supporters who might be skeptical of the media, but are also skeptical of government secrecy. The admission that the president lied about being told he was in the files will be used in campaign ads and oversight hearings. It paints a picture of a man who is afraid of the truth. Long-term, the consequences for the Department of Justice are severe. The department relies on a reputation for independence. By turning it into a political shield, Bondi is destroying that credibility for a generation. If the files are eventually released, and history suggests they almost certainly will be, the contrast between the raw documents and the redacted versions Bondi tried to release will be damning. It will provide proof of the cover-up. We must also consider the possibility of impeachment. If the Democrats regain control of the House, or if the evidence of obstruction becomes undeniable even to Republicans, this cover-up provides a clear basis for articles of impeachment. Obstruction of justice was a central charge against Nixon and Clinton. Using the machinery of the state to hide personal misconduct is a high crime. Ultimately, the logic of the situation dictates that the truth will come out. A secret shared by 500 people is not a secret. It is a ticking time bomb. The administration has bought itself some time with these delays, but they have paid for it with their credibility and their legal safety. The pressure from the courts, the relentless pursuit by Congress, and the inevitable leaks from inside the review team will eventually break the dam. When that happens, the files will be public, and the administration will have to answer not just for the contents of the files, but for the criminal effort they undertook to hide them. The cover-up has transformed a past scandal into a present constitutional crisis, and there is no easy way out for the people involved.